Service Employees International Union, Local 509, and others, v. Suzanne Bump and others.
It's too much.
Thank you.
It's a double header for you, Mr. Russell.
Yes. May it please the court, my name is Ian Russell, and I also represent the plaintiff appellant labor unions in this matter. This case involves an action in the nature of certiorari filed by several labor unions challenging a determination by the auditor in which she approved a proposal by the Department of Mental Health to privatize certain services. Specifically, this case involves the auditor's approval of DMH's proposal to privatize emergency mental health services in the southeast area of the state. I don't believe there's any disagreement among the parties about the importance of these services to the general public.
Okay, how about the standard of review?
The standard of review, we concede that in an action, a certiorari action, that the nature of review changes depending upon the law and the matter that is being reviewed. Here, various of our arguments are based on substantial error of law.
But you also argue substantial evidence, and that doesn't seem correct.
We agree that the auditor is given discretion under the statute as written, and the legislature intended to provide discretion to the auditor. So we did argue substantial evidence, although we also believe that the arguments we have made based upon that certain decisions made or certain findings by the auditor were not supported by the record at all would also survive.
I'm sorry, is there a record here?
Is there
a record? Were there hearings before the auditor?
Well, all of the evidence or all of the documents that were reviewed by the auditor is in the record. So,
But there was no judicial analysis. It was just a team of auditors doing a review.
it was not a judicial type hearing. I agree. There was not arguments presented by two attorneys. That was not how it was framed.
So wouldn't it become an arbitrary or capricious standard?
I think it's likely that that is the standard that would apply. I don't believe the court spelled it out specifically in the MBTA case, but that is likely the standard that would be applied. Under that standard, our position was that the errors of law would be enough, in addition to the lack of record support for certain findings, that errors of law that were made.
And on the standard of review,
Yes.
in the previous argument, the point was made that the determination of the auditor is final with respect to the department. Could the department appeal in the way that you're appealing?
I believe so. I believe that is what happened in the MBTA case.
So you're saying that this is the counterpart of the MBTA case?
Yes, in that case, the auditor objected to the proposed privatization, and it came before this court in a similar manner. So yes, we would say that this is similar to that case, except here we are a party challenging the decision by the auditor to approve a privatization. And without getting into the record, we believe that it is possible to find that the auditor erred solely on legal matters when you look at the manner in which the privatization went forward.
Could I, on that point, just as a factual background question, the original RFR in 2011, was it 12?
Well, no. Well, there are two RFRs, I suppose, at issue. There was an RFR related to the
rest of the state.
The contract that was entered into between EOHHS and MBHP, the private entity.
Right.
And then there's the RFR from 2015, which relates to these particular services.
So the original one.
Yes.
Was there at that time, and it obviously was approved?
Well, it didn't have to go before the auditor in 2012, because in 2012, the contract that was entered into between EOHHS and MBHP didn't have anything to do with the privatization of services.
Why is that?
There has been within the state a history for a while, at least, wherein emergency mental health services were provided by private entities in the majority of the state, but provided by state workers working for the Department of Mental Health in the southeast area.
So
as a-
that predates the Pacheco law in 1994?
It was, all I can say is that I know that in 2012, when the contract was entered into, the MBHP EOHHS contract, it did not cover services in the southeast.
No, but my point and your point, your answer is whatever it covered or didn't cover, it did not go to the auditor.
It did not go to the auditor. In 2012, those services were being provided by private entities, so it was at that time not a privatization contract.
Okay.
Which brings me to the initial argument we have made regarding an error of law, which is that it was argued to the auditor that the 2015 amendment to that contract, which expanded the contract so it would then cover services in the southeast, which were being provided by state employees, that amendment to the contract brought it within the scope of the privatization law, and that should have been competitively bid. But there was no competitive bidding when state services began to be covered by this contract. What happened was the EOHHS and MBHP entered into an amendment of the contract with no competitive bidding whatsoever, and essentially EOHHS, on behalf of DMH, said, you're now going to be overseeing the privatization of these services.
Wouldn't that have been contemplated in the 2012 contract, future privatization?
Well, there was no specific discussion in the 2012 agreement regarding privatization, where it did talk about a large scope of services. But our point is that under the privatization law, when services are privatized, and they weren't privatized in 2012, they weren't even proposed to be privatized until 2015, that the law says that there needs to be a competitive bidding process. And in fact, the auditor, in her determination in this case, said that there may be multiple agreements. In fact, the statute discusses a series of agreements, and that all essential agreements need to be subject to a competitive bidding process. So one of the arguments that we've made as related to an error of law is that the amendment which granted MBHP the ability to start this privatization service and manage services, oversee services in the southeast, was never competitively bid. Essentially, MBHP was provided with a no-bid contract to oversee the services that were going to be provided in the southeast, which theretofore had been provided by state employees.
But I'm just factually, I didn't understand that before, now I do. I didn't understand the earlier one wasn't competitively bid, but this, so the amendment wasn't competitively bid, but the choices of the, is it what's the ESPs?
Yes, the ESP.
Those seem to be competitively bid?
So, yes, there was a competitive bidding process. So in addition to the argument that the amendment should have been competitively bid, an additional argument that we have raised related to an error of law is that the statute, in clear and unambiguous terms, states that it is an agency that is supposed to solicit bids, receive the bids, and then choose and delegate the winning bidder.
What precludes the agency from delegating that?
The clear language of the statute. The language that is used in the statute says that an agency shall. It repeats that phrase throughout Section 54.
But the agency has to act through people, so it's not clear to me why it couldn't
But
delegate that.
it didn't act through its own people. It acted through a private enterprise.
But doesn't DMH have set the parameters?
So,
And didn't it have to approve of the ultimate ESP?
well, all that the contract between MBHP and EOHHS says is that the contracts can be signed at the direction of EOHHS. In fact, DMH is not even a part of the contract, which makes it somewhat confusing as well. That merely has to do with the timing at which these contracts are signed, because the facts, even as they were found by the auditor, show that it was MBHP who determined the manner in which the bids would be evaluated, what scores would be given to them, and even under the contract with EOHHS was specifically given the power to choose the bidders. In fact, in a frequently asked questions document that is in the record, when bidders ask, is DMH going to be involved in the evaluation committee, MBHP provided them with a one-word answer, which was no. This is a core governmental function, which is to determine how funds are spent and to determine who will be providing these essential services.
So you're saying if you went back to 2012 and the RFR said that MBHB was going to be responsible for looking through and determining who the provider was going to be, that would be invalid?
Yeah, well, it would be invalid in 2000 if there was if it didn't go to the auditor in 2012, and
Well, they were already private in 2012, right? In the other parts of the state.
The services in the Southeast were not involved in
Right.
2012. Our position is simply that the statute says that it is an agency that needs to solicit, and then choose the bidders.
Suppose you're right about all of your legal challenges. What's, I have to say I was a little bit impressed by the red brief's argument that you don't have any injury here. What is it that you want us to understand is the problem for the union with the fact that the auditor made all of these errors of law?
Well, in a action in the nature of certiorari, the injury can either be to the plaintiff or to the general public. The injury to the plaintiff is that employees whom it represents are going to be laid off as a result of the privatization, and the various impacts that has on the union that arise from there, the loss of membership, the loss of dues, the loss of ability to represent their members. The injury to the public is clear in that the statute was drafted in order to protect the public from these very types of activities. The general court states in the preamble that they are declaring that that having public services provided by state employees does not always promote the public interest. And in the Senate Committee on Ways and Means discussed the fact that the law was intended to protect the public from new forms of patronage and cronyism that favor well-connected private entrepreneurs at the expense of rank-and-file state workers. There is an injury to the public.
Well, it's BMC, and I mean, are those the kinds of entities that the statute was intended to protect us from? Boston Medical Center, I forget who the other provider is.
Bristol County something.
Yeah,
The law is similar to the competitive bidding statutes, which have been recognized over and over again are intended to create an open and honest bidding atmosphere. And they are intended to be strictly enforced in order to promote the interests of the public. Here, we can't the position taken by the department is essentially that it was more efficient to do this, and we don't think anyone was injured because we probably would have chosen MBHP to do this work anyway, or we probably would have chosen these other parties. But that is pure speculation. We don't know that because there was not a competitive bidding process related to MBHP managing this work, and then the services were not overseen. The choosing of the service providers was not performed by the agency to whom that power is given.
Let me walk you back. The MBHP agreement in 2012 arose from a competitive bid process, correct?
2012, it was competitively bid, but at that time, it did not involve
Privatization.
privatization.
Gotcha.
Yes.
So, but there was a competitive bid, And that competitive bid included, I guess, the possibility within the contract that that agreement could be amended to go statewide. That was at least within the overall scope of the agreement?
It was, the language was broad. It did not, I agree, it was broad. It did not specifically discuss privatization, but
Okay,
yes. it
so,
was
so
broad.
here so I guess the argument they're going to make is, well, we had a competitively bid contract. It provided for the possibility of going statewide. We're going to invoke that provision. And because this is now a statewide organization, they are entitled to choose their local contractors, because we don't expect them to be managing as a statewide entity. They're going to choose local entities to be handling the emergency medical services, which may be existing entities. Why can't they
Well, in which
do
case,
that?
because under the privatization law, if in fact they are being granted the power to be the ones to simply choose subcontractors, that work needs to be competitively bid.
So you're saying that under the Pacheco Act, if whatever DMH decided, let's assume that all of EMS was being done in-house. If they said, okay, we're going to contract it out to a state entity, that state entity could not then have the power to be subcontracting out to local.
Could a state entity, if it,
No, I'm sorry. Let's assume that all of emergency mental health services were being done by state employees in
Yes.
2012, okay? And let's assume, I know it didn't happen, but let's assume that they said, we're going to change that. We want all of this to be privatized. And we're going to basically competitively bid for one entity to be handling all of this. But we're going to give that entity the ability to subcontract out to various local agencies to actually do the work. Are you saying they can't do that?
I am saying that at that point, there would have to be a competitive bidding process to determine who would do that work. And then their contracts with the subcontractors would also come in to review. The entire thing would, in the situation that you describe, be reviewed, be done by an agency, because all work is being provided by state employees and managed by the state in your example. So then there would have to be a competitive bidding process essentially for an entity to come in and replace the state. And then the contracts that they propose with the subcontractors and any contracts there would be reviewed as part of a competitive bidding process, assuming they won the bid. But in your example, it would be the department who would be doing the privatization and who would be choosing the bidders and who would be determining who is providing this work. Ultimately, it would be the agency, an arm of the government, making that decision and not a private entity. Here, we have a situation where it was MBHP, a private entity, that essentially made all of the important decisions about who would be providing this work. And in doing so, various things that would normally happen did not happen. For example, you'll find that the record does not have the losing bidders, because MBHP said we're a private entity and therefore they're not subject to the public records law, so the auditor, you have to sign a confidentiality agreement with this. And
Well, the auditor disagreed with that piece of it.
yes,
right?
the auditor did disagree with that, but I'm saying that that is something that arises from delegating, where delegation of governmental functions is not considered by the law. This court has, on various occasions, we cite to a City of Somerville case, found that government authorities have certain non-delegable powers that cannot be delegated, in various of your cases, that cannot be delegated to the collective bargaining process. And when this court has looked at those cases, they have looked at language similar to that which is used here, which says that a government entity, in this case an agency, shall do X. This court has repeatedly determined that that is a non-delegable right that cannot be delegated to another party. It has to be performed by the government. Here, in contravention of clear and unambiguous language, MBHP, a large for-profit institution, was allowed to make act as the government, essentially, in determining how public funds would
Not without
be
the
spent.
Executive Office in Health and Human Services sign-off. They couldn't do it without that.
DMH and EOHHS essentially handed off the ability to choose who the bidders would be
In 2012 or in 2015?
in 2015.
They say in 2012, and it wasn't a handoff, it was bid.
In 2012, there was no consideration of privatization. It was not a privatization contract. Essentially, they're arguing it became, without any further bidding, the privatization contract in 2015 through the simple act of amending an existing contract. And the statute does not consider an amendment to a non-privatization contract to be somehow, when it then covers privatization, to be somehow outside of the scope of the law. But the position that's being taken by the auditor and by DMH is that somehow when the privatization part of the contract was handed to MBHP, that was somehow not an essential contract in the series of agreements that led to the privatization. And it's our position that that is simply not a rational position to be taken.
Okay, thank you.
Thank you.
Mr. Bertram, good morning.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Assistant Attorney General Brian Bertram for the State Auditor, the Executive Office of Health and Human Services, and the Department of Mental Health, all of whom asked this Court to do nothing more than affirm the State Auditor's decision not to object to a privatization that seeks to align the way the Commonwealth provides emergency mental health services in the Southeast area with the way it provides those very same services in the rest of the state.
But if this is the piece I did not understand before, if the 2012 contract between EOHHS and MBHP was not a privatization contract,
It was
right?
not, Your Honor, that's correct.
So it wasn't subject to the Pacheco law.
Well, it was not then, no, Your Honor, it was not.
So if that's the case, I guess, how does the amendment to add the Southeast not have to be, which it seems as though, given the rest of the steps you say is a privatization contract, yes?
Well, the privatization contract is the series of agreements here, Your Honor. So the original 2011 MBHP contract,
So it becomes one retroactively
I think it becomes
with-
part of the series of agreements,
with
yes, Your
no
Honor.
compliance at the time?
Well, there was compliance. It was competitively bid. The privatization law requires that a contract be competitively bid. It was at the time. They have conceded that.
It was competitively bid, but it requires some other things as well, right?
Well, the whole series of agreements then was subject to that review at the present time, Your Honor. In other words, that contract, the amendment, the competitively bid agreements with the individual ESP providers, that was all provided to the state auditor for her review. Nothing was sort of singled out.
In 15.
In 15 now, Your Honor, yes.
Okay.
But in terms of,
So I'm sorry to interrupt you, but
No,
so
that's
what you're saying is, in 15, it's as though, if I understand correctly, the entire contract, it could have been, was being privatized at the same time.
Yeah,
That's the
it-
kind of review that she did.
that's
is that
correct,
right?
Your Honor, yes. In the state auditor's decision in her report, she did a procurement laws analysis of the original contract and said, yes, it did follow the procurement laws. It was competitively bid. All of that was done. And again, I
No,
believe
I
that's a
appreciate that,
concession.
but the rest of whatever the Pacheco law requires wasn't done at the time, but she kind of looked at it through that lens in 15, is that?
That's correct, Your Honor. I mean, in terms of competitive bidding, I don't think that it's date-specific, so long as everything, that was required to be competitively bid was competitively bid, and it was. I do want to respond a little bit to the way they're framing this 2015 amendment. It's actually Amendment 16, so that can get a little confusing, but it's in 2015. MBHP is the statewide management entity for EOHHS's Medicaid program and its children's health insurance program. EOHHS doesn't view that as sort of individual areas. It's a statewide function. And, for as long as everyone can remember, the Southeast has sort of been different. It has been this public model. The rest of the state has been private. To respond to your earlier question, Your Honor, I don't think anyone has any memory of anything else ever having gone to the through the Pacheco process, so it may very well have predated that. But no one has a memory of everything else being private. But in any event, MBHP's role is not sort of area specific. And so I'm not going to go into the granular details of this, but it is the position of the auditor and the agencies that that original contract contemplated the provision of statewide services. And for that reason, under the procurement statutes and the procurement regulations, there was no requirement to rebid that small piece of the series of agreements in 2015. And again, I just want to emphasize, the original contract was competitively bid, as were the individual contracts that MBHP will enter into with each of the individual ESPs in the different sub-areas in the southeast area.
Just one last
Yep.
piece on this. So part of that would be the pieces of the Pacheco law that talk about looking at what are the salaries, et cetera, et cetera. That wouldn't apply to the retroactive review of the 2012 contract because the people weren't public employees at the time anyway.
No, they were not public employees.
So the only pieces of the Pacheco law that would come into play are the ones you talked about, the procurement laws and
The procurement law is the compliance with any other relevant law, which I think the auditor's office views somewhat expansively, which is why the procurement laws get swept in. The minimum wage and benefits to the extent that privatization actually occurs prospectively. And the general sort of overarching requirements of the statute, I think, which are really twofold. First, just to create this entire analysis and put it in one place, subject to the public records law, the old maxim, sunshine is the best of medicine. It's all there, everyone can see it. And then creating that so that it can be reviewed by the auditor. And undoubtedly, both of those things happened here. The extensive analysis, for example, is reprinted in full in our supplemental appendix so that the court has all aspects of that. And then the auditor was able to review it. I think specifically looking at their argument that the agency has to specifically do each of these things, we've argued in our brief that while it says agency, the agencies certainly did things here. For example, the DMH, EOHHS, in conjunction with MBHP, they developed the statement of services. So there's really no argument here that the agencies weren't involved in that process. And I would argue to the court that that's a pretty important document as it spells forth exactly what services need to be provided, how they need to be provided, how it's going to be measured and tracked. At that point, we don't dispute there was something of a limited handoff to MBHP because this is the overarching management entity, so it administered the competitive bidding process for the individual ESPs. Argue that that makes sense since MBHP will have to oversee them, will have to have the direct contractual relationship with them. But at the end of the day, as we argue in our brief, ultimately nothing can actually happen unless it's at the direction of the EOHHS. And indeed, maybe it's not a legal proof of this, but we have entered into a standstill agreement in this case where the EOHHS and DMH have said, we won't move forward with this until this court challenge is resolved, and it hasn't happened. Those contracts are not being entered into because EOHHS and DMH have the final say-so over that. So given that process, the fact that DMH and EOHHS are involved in an ongoing role after that, I think that the auditor was certainly correct, without any ambiguity in the statute, that the policies of the privatization law and the structure of it allows that to happen. But to the extent there's any sort of lingering question, any lingering ambiguity, the auditor should get deference here because the privatization law was given to her to implement, given to her charge, and under standard principles of deference, she should get that.
I'm sorry, go ahead.
I was going to say, seeing no further questions on this.
Well, there are now,
Yeah.
so.
I figured that might be the case.
Help me to understand your view as to what the purpose is of the requirement for public bidding in the Pacheco law. I mean, I gather that there really are two things going on in the Pacheco law. One is to make sure that work done by state employees are not given to political cronies, and therefore there's a public bidding process to ensure that that does not happen. And a second process of comparing whether or not the public is served in cost savings by doing that. Is that right, or is there are there other purposes behind the public bidding that go beyond simply the avoidance of cronyism and the insurance that the contractor will set parameters to permit that comparison?
I think that's largely correct, Your Honor, and it's all in furtherance of, again, creating the sort of super package of materials, the large analysis that goes to the auditor that's available to the public. And just to place it into context, I believe it's really essentially a gap filler. You know, under just the Procurement Act, the procurement
In that sentence.
what was that?
The Pacheco law is a gap
The
filler?
private, yes, the privatization law, the Pacheco law, Your Honor. You know, previously, had someone determined they were going to privatize, you know, the procurement laws might require you to competitively bid it to all these different agencies. But I think that the privatization law sort of puts out another overlay too, which is if we're assuming we're going to privatize, let's make sure it actually makes sense, which is not necessarily something that, you know, procurement laws, which govern only bidding to private entities, would cover. So I don't know if that answers your question, Your Honor. You've got...
Well, I mean, the question, of course, here is the public bidding requirement in Pacheco satisfied by the 2012 competitive bidding? And that's where you differ.
Yes.
And I'm trying to understand your position as to why that is satisfied by a competitive bidding that was done in a non-privatization context.
Well, because there wouldn't have been anything different. You know, you put it out to bid, people bid on it. And here again, this was the statewide sort of high-level administrator for services that was bid out to MBHP in 2012. You know, notably absent, for example, from the other side's briefing is any sort of contention that there would have been another entity than MBHP that all of a sudden, if they had understood that something was different, would have bid and would have come in with a lower bid.
Was MBHP the only bidder?
I don't know, Your Honor.
I mean, but, well, let me ask it this way. When the auditor reviewed it in 2015 or 16, was it before her however many bids there were back there in 2012?
I don't believe that was in the record, Your Honor. I think that given the fact that DMH, EOHHS in their submission represented there was competitively bid, and there was no disagreement from the unions, who aren't disagreeing on that point today. They've conceded it. I don't really think there was any question that competitive bidding requirements were followed in this case. And again, I don't see any sort of delta, if you will, between following the procurement acts, the procurement regulations, and the privatization law, at least as to this specific issue where, you know, before privatization is proposed, MBHP fills a certain role as the central administrator. After privatization, they're doing the same thing. They may have more entities underneath them, but their role, their function, what they are doing remains unchanged post-privatization. It's just that they have entered into a few more contractual relations with additional ESPs in the southeast area to make sure that individuals get services there too.
The series of agreements also includes the last set of agreements, correct?
That's correct.
Which are going to be competitively bid.
The ESP, the individuals, yes, those were competitively bid, Your Honor. That was the process that, you know, we've argued about how involved the agency should be, but I don't think there's any disagreement between the parties. I certainly don't read it from the briefing that that was not at least competitively bid. And the question really is a matter of form over substance at that point. Should everything have come forth on state letterhead, or, you know, was it enough that we followed the process here and furthered the policies of the privatization law, which is to propose a privatization that will not diminish the quality of services, and we know that from past data that it won't, and will save taxpayers money. And here it's going to save them $7 million, which the auditor found to be $1 million in excess of what the DMH actually thought it was going to save. So seeing as though my time's running short, I'm going to pivot a little bit unless anyone disagrees to the quality of services issues.
Yeah, before you get there, do we need to reach the minimum wage requirements in Pacheco issue in light of the concession that the agency will continue to comply with that in the renewal period?
Well, I don't think so, Your Honor. That's certainly what we've argued. I think that, you know, if we've all agreed, and it seems that we have, that this is an arbitrary and capricious standard of review, the fact that it is in a written submission to the auditor that these will be complied with was a decision made by the agencies. They didn't want to fight this issue in this case. That it certainly can't be said that it's arbitrary and capricious to rely on a written representation where, if you look back at the privatization law itself, it requires written certifications. So that's good enough for a lot of other things in the law. I think that it ought to be good enough on this particular issue too.
Okay, you may now pivot.
Thank you, Your Honor. With respect to quality of services, unless there's questions as to sort of the specific challenges that are raised here, I really just want to emphasize to the court that unlike some other privatizations that have occurred where you sort of come in and take a state service that has wholesale been state, replace it with a private service, this one's a little different. Everywhere else in the state, services are provided through this model. And apples-to-apples data has been collected because MBHP is in this overseeing role. And based on measures that are important to the DMH and the EOHHS before privatization now, we know sort of two related things. First, the DMH does a good job in the southeast area. They provide quality services. But related to that, the private ESPs in the rest of the state do at least as good of a job as the DMH. And that's what must be shown through the privatization law. And based on that objective data, it was. So unless the court has any further questions for me, the agencies and the auditor will just rest on their briefs.
All right, thank you.
Thank you, Your Honor.
We'll take our morning break.
All right.